All right. Thank you for staying with us. It's 7 minutes into the 10 o'clock hour. Time for Probono Chambers on Human Rights Radio 101.1 FM. I am Ruth Usman, and I have two barristers, two in-house. I am a little bit excited. Barrister Musa, where have you been?
I've been around.
Where?
Just around, at least we have been.
Have you been seeing him?
We've been seen once in a while.
I can't remember the last time I saw him.
Aha! Today we're going to expose you. Your secret shall be known world over.
You've already said when next I'm online you're going to expose me. Please, pardon me for that.
I shall think about that. Right now I feel like a judge. Okay, so we're all welcome to Probono Chambers today, and as always we'll begin with a focus, and our focus for today is vicarious liability. That's what we're going to look at today. So we'll see what the listener out there can benefit from this, because we're all about educating you, we're all about enlightening you, especially in the area of the law, you knowing your rights, or where to put your right leg and your left leg. Literally, we can teach you that on Pro Bono Chambers. So welcome once again to all our listeners. So let's begin. What is vicarious liability?
Okay, to start with, vicarious liability falls within the limits of torts. And like we have said some time ago in one of our episodes, tort is a civil wrong for which the law will provide a remedy. So with that at the back of our minds, we would know that vicarious liability is a tort, so it is a civil wrong. However, it means basically where an employee is held responsible for the wrongs, civil wrongs committed, an employer is held responsible for the wrongs committed by his employee towards third parties. In other words, the employer is now liable to the third party for the wrongs committed by the employee. Now, those are subject to various circumstances. We will examine what these circumstances are as we continue in the course of the discussion. However, I must state that this is a derogation from the fault principle, where the law says where you are the one who is at fault, then you are liable for whatever wrong it is that is on ground. However, now
can you take that again?
The law says in tort, where a person has committed a tort, he himself is liable to the other party. In other words, he bears the consequences of his action towards the other party. However, when you now come to vicarious liability, it means that where an employee has committed a tort or has done something wrong towards a third party, a person who is not within this scheme of things now, then his employer becomes liable to that third party and not the employee himself. Now, we must state that this is usually between employers and employees, not between husbands and wife. In other words, you cannot hold the husband responsible for the tort committed by his wife, or parents and children, or all other forms of relationships.
Okay, so vicarious liability is simply for employer-employee relationships?
Yes, majorly.
Okay.
And this is because the law presumes that the employer is is the one who is more comfortable, or who has the means to correct the wrongs of his employee. He has the wherewithal and the means to do so. So the law holds him responsible for the wrongs that has been committed by his employee.
Interesting.
And again, not in addition to that, the wrong committed by the employee should be within the scope of his employment. If an employee acts outside the scope of his employment, most times in such an instance, the employer won't be held accountable for that.
Okay, for example, I am at home and I well, it might have been a mistake, but then I destroyed something that belongs to my neighbor. They will not go and call my employer. Is that what you're saying?
They can't call your employer for that, because such an act was not connected in any way with your work or has any connection with your employer. You are on your own. That's just it.
Okay, what we're trying to say at this point is there are two tests to determine who should be held vicariously liable in a tort. One is whether the tort was committed by the employee, and secondly, whether the tort was committed by the employee in the course of his employment. So if, for instance, I am an employee of company X, for instance, and then I am a driver for that company, and I drive one of their probably delivery vehicles or anything. Maybe I just assume I'm a driver for that company. And then in the course of I have been asked to go and deliver maybe a particular item to a particular location. And then on my way, I negligently hit another road user. What the law says is that my employer will be responsible, will be liable to that road user in tort. In other words, he will be the one that the law will hold responsible to fix the damages I may have, that may have been occasioned by my negligence. Now, we must note that it must be in the course of my employment. It must be within the scope of my duties as an employee of company X. So if, for instance, company X says I should go to Gariki and drop a particular item from here, and of course from this point to Gariki there is a route I could use, and then all of a sudden I now discover that, okay, let me just quickly dash off to
Maitama.
No, maybe not Maitama, maybe somewhere like Lube that is actually outside of my duty, totally. And then along that route to Lube or somewhere, I now hit somebody at that point. Then at that point, you're your own. You will not hold your employer. The law will not look for your employer at that point.
Even though you were still driving your employer's car?
Yes, because at that point, within that material time, I was actually supposed to be carrying out the instructions of my employer. However, I went on my own frolic. My employers didn't say, go to Lube. The instructions were, go to Gariki, drop off item P, and come back. And then I went to do whatever it is, carry out my personal business, and then something happens in that time. Now, that is one. Then secondly, another question arises, how do we determine who is an employer, an employee rather? Now, there are two kinds of persons. We have the independent contractors, and then we have employees. The test to determine this is the control test. Like, how are we able to establish who is an independent contractor and who is an employee? Because, for instance, I can have, let's say I have a contract to build the house, and then in the course of building, I have to bring in tilers. They are not my employees. I subcontracted them in and then have them come and carry on a particular job.
Once they're done with that, they're off.
They are off. In other words, they are not specifically under my payroll as my employees. They come in as professionals, do their job, and go away. Now, when that category of people come in, it means that I will not be liable for whatever they do because I do not control them. So if I bring them in, they come in as professionals in their own right, they do their job and they'll go away and they are paid, and that's it. Now, if in carrying out that duty, they commit a wrong or they don't do that job well, and then it results in probably one form of damage or the other, at that point, we begin to look at we begin to hold them responsible for that act, and we won't hold the the employee now, the employer, the head now responsible. That would not be the case if I am under his employment as a staff. If I am a laborer, or I am a merchant, or I am anything directly under his employment. In other words, he controls my activity. He controls how I carry out that assignment. As an independent contractor, he doesn't do that because I come in as someone who has professional experience and I do my part and walk away. No, but on this other hand, he controls how you carry out your activity. He controls how you perform your job specifications and all of those. So you are an employee now because of that control. So where in the course of carrying out that activity, you now commit a tort, he is responsible for that.
Earlier you said, well, you used the word negligence, so I just wanted to see or to understand. Now, what if it is actually determined that, you know, or ascertained that you were actually negligent? For instance, you used the example of being a driver, so you were driving and you were supposed to pay attention and you were not being very careful and you ran into another car.
Yes.
Now, and it's you know, really been ascertained that you are at fault. Would your company still pay the brunt?
Yes. Now, so long as it is established that that was in the course of my duties as an employee. That's the first angle. Now, where it is established. Now, the point is, the law seeks a way to protect the interest of that third party who suffers the brunt of your activity. Now, the law would not say the driver should go and pay him, because the driver may most likely not have the means to fix his vehicle or to probably pay his health bills, his hospital bills. Now, but the law will hold his employer responsible. Then it now behoves on both him and his employer to sort themselves out. So the employer can decide, okay, fine, you have been negligent in your duties and you cannot continue in my employment. That's another thing altogether. However, in the course of carrying your activity, whether or not you were negligent, if you cause another man to suffer consequences of your act whatsoever, you will, the law says we would hold your employer responsible first of all, and then get him to pay you damages or compensation or something. So
is this something that should be included in the agreement contract or something? If you're about to be employed, they tell you that, well, in case of anything happening such as this, we will deduct from your salary, because we've had people who say, oh, something like this happened or something was stolen, and then they say, well, so number of people will have to, you know, pay for it, and then they start deducting from your salary. Should there be anything like that in an agreement first before?
Where parties, every agreement is binding between both parties. So long as it does not derogate any standing rule of the law, then that's fine. So if there is such a clause in the agreement and both parties feel that they are fine with it, that yes, where we incur losses as a result of your activities, then we will deduct them from your salary, and then you agree, that is fine. That is between the both of you. Once you append your signature, it means, yes, I agree to this term, and it stands binding between the employer and the employee. That's for them.
Okay.
But when we talk about the activities of the employee now, as it relates to the man on the street who is not privy to their employment contract, then that's what we are looking at now. How does the law compensate that man there who will, one way or the other, because we have various cases of companies carrying activities of companies where consumers or innocent third parties on the road suffer the consequences of their activities, most especially when it comes to driving. Mostly you see company vehicles hitting people, other road users. In many circumstances, you know, people suffer suffer one form of civil wrong or the other as a result of the activities of employees of companies. So the law is saying that where a person suffers as a result of that, then we will mandate the employer to be the one to compensate this person, while they can then maybe they will have internal mechanisms to sort themselves out on the other side. That's for them. But at this point, we try to hold the person who we feel has the means and wherewithal to compensate you first of all, so that we can settle you first of all, and then they can now do
their internal matters later. Okay, we'll come back to that after this break. Stay with us on Human Rights Radio 101.1 FM.
Anywhere you go, wherever you are, we are your family. Human Rights Radio 101.1, redefining broadcasting.
Udummiri ebidola a na-adọ ọhaneze aka na ntị ka ha gbochie ma kwụsị akparamagwa ga-ebute mmiri ọdụdọ na mbuze dịka iwufu ahịhịa n'ime mmiri na-asọ asọ ya na ịtụnye ihe n'ime gota. A na-emekwa ka ị mara na iwu ụlọ n'ebe na-ekwesịghị dịka ụzọ mmiri nwere ike ịkpata ịtụfu ndụ ndị mmadụ n'efu ya na ihe nweta ndị mmadụ ịla n'iyi ma ihe kwesịrị dị mma. Ọ bụ Federal Capital Territory Administration FCTA na-ezitara gị ozi a.
As the rainy season begins, the general public is hereby advised to avoid environmental practices that could cause flooding. Indiscriminate waste disposal has remained a major factor causing flooding in the FCT. Do not throw your garbage into gutters and drainages along waterways. Residents are also advised to avoid building houses around natural waterways, as this could also lead to loss of lives and property during the rainy season.
Do the right thing. This message is from the Federal Capital Territory, FCTA.
Damuna ta fara kankama, an shawarci al'umma da su guji bata muhalli wanda ke iya jawo ambaliya. Zub da shara ba kan gado shine makasudin babbar ambaliya a birnin tarayya Abuja. Saboda haka kar ku zub da sharar ku a magudanan ruwa. Bugu da kari, an shawarci al'umma da su kiyaye yin gine-ginen gidaje a hanyoyin ruwa, wanda yin haka kan iya jawo rusan da zai laƙume rayukan al'umma da dukiyoyinsu a lokacin damuna. A koda yaushe ku kasance mai yin abin da yake daidai. Wannan sako na zo muku ne daga hukumar birnin tarayya FCTA.
Wani ya samu wani yana
gẹ́gẹ́ bí a ti mọ̀ wípé àsìkò òjò la wà, èyí ni láti sọ fún gbogbo ènìyàn láti yàgò fún ìwà ìdọ̀tí, dídà ìdọ̀tí síbi tí ò bójúmu tí ó lè fa omíyalé, àgbàrá ya ṣọ́ọ̀bù. Dídà ìdọ̀tí síbi tí ò bójúmu tàbí òpópónà sì jẹ́ ohun kan gbòógì tí ó ń ṣokùnfà omíyalé, àgbàrá ya ṣọ́ọ̀bù ní ìlú Àbújá. Ẹ má ṣe da ìdọ̀tí sínú gọ́tà tàbí ọ̀nà tí ìjọba ti pèsè sílẹ̀ fún omi láti gbà kọjá. A tún fi àsìkò yìí sọ fún gbogbo olùgbé FCT Àbújá láti rí dájú wípé wọn ò kọ́ ilé sí ọ̀nà tí omi ń gbà kọjá. Èyí lè ṣe okùnfà pípàdánù ọ̀gọ̀rọ̀ ẹ̀mí tàbí pípàdánù ohun ìní ní àsìkò òjò. Ẹ ṣe ohun tó tọ́. Ìkéde yìí wá láti àjọ FCTA, Federal Capital Territory Administration.
When you require quality output that makes you the professional that you are, there are people you should ask. Ask us at Austin 7070 Nigeria Limited, because at Austin 7070 we deal in professional digital cameras such as Canon, Nikon, Phantom, Sony, Panasonic, Blackmagic, and all kinds of photographic equipment. Visit us now at Banex Plaza beside Fidelity Bank, Wuse 2, Abuja. You can call us on 0708 974 9733. 0708 974 9733. We also have London used laptops from 40,000 naira and above. Austin 7070 Nigeria Limited. You love quality. We believe in quality products.
Welcome, my dear friends.
Human Rights Radio. Your 100% effort is not good enough. Give me 101.1 effort.
Join our diverse team of legal experts as we provide education and guidance to you, our listeners, on a broad array of issues raised by the modern legal landscape, absolutely free on Probono Chambers, airing on Human Rights Radio 101.1 FM, redefining broadcasting.
Human Rights Radio.
All right, it's 10:28 a.m. Thank you for staying with us. Probono Chambers continues. Today we are looking at vicarious liability, and we have really listened to so much from both Barrister Musa and Barrister. Why am I starting with the guy? It's ladies first, Barrister Uche,
because we
and
have
then
that connection between us. That's why I have to.
we're supposed to listen to you.
Well, like earlier said by my colleague, I'll try to talk more on the scope of employment. And the scope of employment talks about the terms of agreements, that the terms in which binds both the employee and the employer, the employee and the employer. In this case, we have instances where employee acts on their own without due instructions from their employer. In such an instance where employee acts on their own, such an employee will be held accountable for such wrongful act. And then we have instances where employer is not held accountable for wrongful act of an employee. Like she earlier said, an independent contractor is someone you just contract to do a specific job for you, and is not a legal employee in the sense that he's not working with you like he has this binding contract or agreement between the both parties. For example, maybe you're building a house and you get a painter, a tiler, and all that. After their job, you just go your separate ways, no binding connection between both parties. In such an instance, any wrongful act being carried out by such person, such independent contractor, the employer may not be held liable for such damages. And so also illegal acts being carried out by employer. Yes, even though you're working for an organization and you carry out an illegal act, in such an instance, your employer cannot be held accountable for such illegal acts being done by the employee, because it has no connection whatsoever with your normal day-to-day activity or duties you are supposed to do. And there are other instances where employee act on their own frolic, in the sense that in the course of you, for example, let's say we are operating a courier service organization or something, and in the course of you trying to deliver some product or goods, you now discover that you are short of gas or something, and you now dash into the filling station to top your petrol, and along the line you have to brush someone else's car. In such an instance, your employer might or may be held liable, because in such act is still within the course of you carrying out
Is it still a may thing or will?
Or will.
Yeah, because I mean, you needed more fuel in the car to carry out, to be able to reach your destination.
Yes, in such an instance, the employer will be held accountable for such an act, because it's still within the scope of you carrying on with your duties. But along the line of you carrying out your duties and you now discover that, or maybe you forgot your phone at home and you want to rush home to get your phone, and along the line you were involved in an accident, such an instance, your employer cannot be held liable.
I will insist that he should be held liable because you were hurrying in the first place to go to his place of work where you also work, and then you forgot something important. It may be personal, but I mean, you use that to perhaps communicate even at work. So it's either it could be a personal phone or a what is it now? You use the phone formally at work.
Work phones are meant for the office, not for the house. You're not supposed to take your office phones.
Forgot.
You're not supposed to take your office phones.
That's what I'm saying. So whether it is the office or the personal one.
It's negligent on your own part. Office phones are meant for the office, and your personal phones
going to be my defense.
Meant for you alone.
Sir, I was in a hurry to come to work and I forgot my phone.
Well, your defense might not suffice, or it might not hold enough water.
Find a way to make it hold plenty water.
It might not hold enough water. So like I was saying, in such an instance where you try to dash home and along the line you're involved in an accident, your employer cannot be held liable because such an act was not in line with.
Okay, but what if you took some permission from work and you told them that, okay, I actually forgot my phone, I would go home, pick it up, and then head to the other destination, and permission was granted, and then something happens like that?
In such an instance, that would be something for you to settle between you as the employee and the employer, where maybe an accident happened along the line of you going back to pick your phone or something. But I don't think the employer would want to take the whole burden of the damages alone.
And I'm thinking too that maybe some employees may also want to take advantage of this and say, well, it doesn't matter. I mean, since I know that my boss will handle this, so whatever happens. So what can perhaps the employer do?
The law will always have a way of going down and digging deep into the surrounding circumstances.
Okay.
So the possibility of carrying out foul play might not be as easy as you think. Now, where circumstances are surrounding a particular situation, the law will try to unravel what exactly, because the point is you must be an employee first, and then secondly, it must be done in carrying out your duties as an employee. So within the scope of your duties, one of the questions I think will be asked is, how relevant is that phone? And then a lot of other questions. How does it apply to your job specifications and all of those? So the major thing that we are looking at now was this thought committed while you were performing your duties as an employee? First of all, that is, if you are an employee in the first place. So it is on the premise of these two factors that will begin to now spread and then begin to unravel the other circumstances that follow. If your wife was in labor and you needed to drag her to the hospital, and then in the course of that, of course, that is not part of your job. All of those things are things that the law will consider before they arrive at a final verdict. And like he said, sometimes too, employees carry out illegal activities, that is, criminal activities. Now, the general rule is that your employer will not be responsible for such criminal activities. However, where the person was under duress to carry out that activity, then the employer now may be held liable, and where that activity was carried out on his instructions. So we have all of these circumstances. A lot of scenarios abound. Hospitals, doctors in hospitals carrying out abortions for the hospital, and all forms of activities. All of these are rolled, and where these things happen, the law will begin to look deep and then try to unravel these circumstances to arrive at the final verdict.
Interesting. 08033221149. It's time for us to open up the phone line, so you can call in if you have any question, and feel free to ask. You get to interact with our in-house barristers Uche and Musa this morning on Probono Chambers. Once again, the number is 08033221149. And that is the number to call if you want to be a part of the program. Hello?
Good morning, Ruth.
Good morning.
Good morning, Barrister Uche and Barrister Musa.
Good morning.
Good morning. My question goes like this. What if an employer closed from work and he normally drives the company vehicles home and take it back to the office, and on the process of going home, and he closed from work, and subsequently an accident happened, right? So who is supposed to be held responsible? That's my first question. And then the second question is, when the employer closed from work and maybe he closed up around 4 o'clock, I'm supposed to, by nature, by 5 o'clock, in a 1 hour drive, he's supposed to reach home, and he ended up turning up around 8 to 9, and something happened along the road. Do you get me?
Do you get him?
No. He should come
Okay,
again with the second
can you repeat the second question?
Okay, the second question goes like this. An employer closed from work around, let's say, 4 o'clock.
In the evening?
By nature, he's supposed to drive, 1 hour driving will take him home. So he's supposed to arrive at his home by 5 o'clock. But he ended up arriving home by 8 or 9. And between that time, something happened along the road. But he has not gotten home. Right? So I want to, and maybe he brought someone or he hit someone. So we're supposed to take responsibility.
Okay.
Yeah.
I hope we can remember the first question.
No, the first question goes like, employer supposed to, he closed from work, and in the process of getting home, something happened, he scratched someone or he hit someone. These are like similar questions, but in the middle of time.
Okay. All right, thank you, Jimmy.
Yeah.
Okay.
In respect to the first question, where he rightly said after the close of work, in such an instance, the employee will be held liable because it's outside office hours, and going home with office vehicles, I believe it's not one of the...
It is allowed in that particular story.
Oh, it's allowed for
the
drivers.
He said usually he takes the car home, and from home to...
That means the
work.
employer is aware of it.
Yeah.
Then in such an instance, the employer also will be liable because such an act was done under his knowledge. He permitted such an act, so the employer will be liable for such negligence.
Okay. So following that, the employer is supposed to get home at least by 5. Now, maybe he went somewhere, but he was still on his way home, and something happened, and he didn't get back home until like 9 p.m.
The employee will be held accountable for such an act.
Okay, why?
Because he said he is supposed to go home, and he went somewhere on his own frolic. So, in such an instance, he will be held liable for such an act.
Okay. I hope you got that right, Jamil. Hello? Hello? Okay, bad connection there. Feel free to call right back. It's Probono Chambers on Human Rights Radio 101.1 FM. Let's hear your questions. Hello?
Hello, good morning.
Good morning, welcome. What's your name?
My name is Enyibio Idonset. I want to be with Ordinary President.
Well, not at this time. It's a different program holding right now, okay?
Okay, no problem. Just to help us pass the message to him that we've agreed that the elder should come back. We don't have the resources to keep him there again.
Okay, well, whatever it is, please, perhaps you should come to our office so you can properly pass the message. Thank you.
Okay.
All right. Probono Chambers 08033221149. Hello.
Hello.
Good morning.
Good morning.
Welcome. What's your name?
This is Marcel calling.
All right, I'm listening.
My question is this: I just want to ask a question concerning the agreement for signing a contract between employer and employee, where some terms and conditions may likely be stated concerning who take responsibility of maybe negligence. So I want to ask a scenario where we have issues where some employees, because of their desperateness, maybe frustration of being out of work for some time or not being employed, may be willing to agree to anything, even if it's against him, maybe at the long run. So what if you have that scenario where an employee was not supposed to sign ordinarily, and maybe he signed it because he really needs the job, and that if some social things happen out of work or in the course of discharging my duty, I should be held responsible. You will be thinking that maybe you may be extremely careful and avoid it, but circumstances may come that those things may likely happen to him. So in that scenario, if he later regret that he could have not in the first place signed what he signed, that has now bounced back on him, what will his law do concerning to that to at least to protect the interest of the employee? In the sense that maybe he ordinarily could have not signed it, but due to frustration or other circumstances, he signed what he was not supposed to sign.
Okay. Thank you for your question.
Yeah, thank you.
I want to answer him, but I will not. Go ahead, because no.
Okay, the point is, one of the reasons that could vitiate is a particular contract is if it was signed under duress. Now, I would not be able to exactly know what exactly the clause is that would be to his detriment. But the point is, it is always advisable for people to read through any particular document before they sign. Now, that's on the one hand. On the second hand, you owe your employer a duty to carry out your duties with caution. So where, or in carrying out those duties, you now exhibit some form of negligence that, because whether we try to agree or not, notwithstanding the fact that the law says it is this employer that is more capable to handle the loss, to compensate the third party. The point remains that the company will suffer a loss, and it is not good that that loss is occasioned by one employer, by one employee or the other. Okay. So now I'm sure there will be internal mechanisms.
I'm not quite sure you got the question very well, because whatever duress there is here is self-inflicted. He said that due to, for instance, in the Nigerian society now, so many people are out there frustrated. They've not been, on a job for a very long time, and then now there is an opportunity, but then there's this clause. Perhaps it was boldly written in the agreement that, well, even though you're a driver, or if anything happens on the road, whether it is, whether you're carrying out your duties, you will still be the one to pay. So he's like, well, on a good day, I will not sign this, but I am frustrated. I need this job. I have read this and I understand it, but then I'll just try my best to be careful so that I don't have any accident. That's what he's saying. You signed it out of frustration, not that the employee said you must and you must do it this way. Clearly, it's been written in the agreement and he has read and understood. But then I'm just saying, I've not been, working for 20 years now. Now there's an opportunity. Let me go for it. I'll just try not to have an accident. And then it happens. So he's saying now, what can the law do to at least help this employee who, out of frustration, agreed to such a contract?
Though there is a term of agreement which you signed, and the law has clearly stated that you should go through any documents, not even your terms of agreement, any document you are to sign on, to append your signature on, you are to go through them carefully and make sure that you thoroughly understand it before signing. In such an instance where he's claiming that under frustration, I don't think that would be enough ground of defense for him to say he was, because nobody forced him into signing it. It's not that the employer pointed a gun to his head that you must sign this or something. He read it and he understood it, and he is going to be bound by that terms of agreement which he signed.
But the economy frustrated him. He was okay. Well, I guess that's just it. Since he said he read, understood, but then he was just willing to take a chance. Hello.
Hello, good morning.
Good morning. Welcome to Probono Chambers. What's your name?
My name is Hannatu Yakubu, calling from DC.
All right, Hannatu Yakubu, we're listening.
I want to contribute to what the barrister is at the moment saying before my call interrupted. In every agreement, I'm an employee. Before I sign to any agreement or before accepting any employment later, it is expected that even if it is the government that employs you, there are terms and conditions which they stated there. Like being available to the job you are being given, avoiding cruelty, you don't want to be don't come to the office but you want to be paid and all these things. But in a situation whereby you are being given government vehicles, some people, we are people with individual differences. Somebody may come to like, okay, the government car, I can drive it anyhow, and by the time, government probably, or any ministry or any either government or private that you see happen, some sort of thing. It has probably gained some experience that some drivers will get to the point. When you see a company goes on the road, you see a number written, how am I driving? So there is that tendency that in one way or the other, those companies or ministries have observed that they have been responsible to many misbehaviors of their drivers, and they will do, some drivers will even abscond and even leave their career. They will go, in as much as they have the opportunity to go away with life, then they will leave the liability for the company. So as an employee, you should know that before God and man, you are looking for God, now God has blessed you. Once you are disturbing your duty sincerely before God and man, there is a way God will see you through, to the point that even if accident comes, they shouldn't be that completely inhuman that they won't feel for you. Even if they say you should go ahead, fix up whatever has been damaged by you. But as an employer, I'm encouraging people that whenever you are being employed, you should discharge your duty with care as if it is your own. But once you put that attitude up, I don't care, I'm just employed, I'm looking for my daily bread. If it is about frustration that you have been looking for job as a lot of Nigerians are frustrated without a job. So if you are frustrated and you get a job, there should be that same density to discharging the duty at which you are being given the job for. So that even if anything happens, if the company says, okay, this is the agreement you signed with us, your character, the attitude will speak for you, and that's the immunity. That's my contribution.
All right. Thank you very much, Hannatu, for that advice, and I hope those listening would take a clue from that. Okay, let's see if we can get one final call.
Hello.
Good morning.
Good morning, ma.
Morning.
Good morning, ma.
Morning, you're welcome.
How are you, ma?
Fine, thank you. How are you?
Yeah, just fine.
Okay.
My name is Abubakar Bakadamba. I work for Chimbi, Niger State.
Okay, Abubakar.
Quickly, please, what's your question? I the grade 2, ma.
Oh, okay.
Thank you. God bless you.
You too. Thank you.
Amen.
All right, so he was just calling to greet us, and we appreciate that. Hello.
Hello.
Good morning. Welcome.
Good morning.
What's your name?
My name is Della.
Diana. All right, so what's your question?
I want to come by the family. I want to ask her to take the call.
This is not a pro bono question. All right, if you want any, to make inquiries, why don't you just come to our office, okay? Our office is close to Games Village.
Okay, ma.
So yes, you can find your way there, and I hope you find your answers.
Thank you, ma.
All right, you're welcome. I'm not sure we'll be able to take on any other question. Looking at the time, we may not want to rush. We may not want to rush to answer your questions. So even if you are calling right now and you have questions, perhaps you should just hang in there and let's just push it to tomorrow. But any words of advice, to Nigerians, especially as it concerns some clauses or the rules of engagement, especially when you're applying for a job?
It's always good to not just employment agreements, but all forms of agreements, all forms of documents. Read them thoroughly. Because it's not just about signing. Sometimes when you take tickets and receipts, there are clauses there. There are these words that are written in fine print that sometimes without glasses you may not be able to read them. But it's always very advisable to be sure what you're getting yourself into before you
append your signature.
You accept one way or the other. It's always very important, because I've seen several times where people just collect documents. You don't even care to know what it's all about. I've seen someone sign a tenancy agreement right before me, and he didn't even bother to, he paid, he didn't even bother to read. And I just didn't know what to say to him. I just watched him, and I just hoped, prayed that he wouldn't get into any situation where he would call for that document and begin to find out where those clauses or those terms are coming from. It's always very, very important to look at documents from whoever, from parents, from siblings, from business partners, from acquaintances, from friends. Wherever that document is emanating from, it's always very important that you read them and that you understand them. Where you don't understand, ask questions and be sure that it is properly explained to you before you decide to either append your signature or refuse him. It's always very important. And then for employers, now it's looking as if, okay, the whole liability is now dumped at the doorsteps of employers. It's good that employees get proper training, that you also understand circumstances where they may commit torts that will involve liability towards third parties. And then it's also good to always have insurance too. This will save you, protect your interests one way or the other.
And I think, like Annette mentioned, I've seen such buses on the road where you see how is my driving and all of that. I think if they take such measures too, it can help.
Yes, to monitor the activity. Many times, yes, I've seen them to school buses, company buses, company vehicles. These are done to monitor the activity, because of course
some of them cut part of the numbers, so you see that maybe the last 2 digits are out.
The truth is the employer is not always there to monitor the activity of his employees or to see how well they are doing on the job. But whatever situation or measure you can put in place to watch out or to monitor the activity of your employees, just so that they don't go out there and commit torts or carry out activities that will bring you unnecessary liabilities and all. It's always very important.
Barrister Uche, have you read all and everything you have ever had to agree to before signing?
Maybe before I became a lawyer, no. But now, I try as much as possible.
If you're going to download WhatsApp now, you're going to read all the terms and conditions and other apps. See, that's, you say we read everything, even those in fine prints.
I've used WhatsApp before, so maybe sometimes I take my time to
Okay, now there's going to be a new app.
It's very important, and even for products. We don't exercise the kind of caution we ought to. You buy products, and it's until you've gotten home that you discover that. I try to form that as a habit. I've not been perfect with it, but watch out for some of these things. Know what the expiry date is. It helps you know whether it has the necessary numbers and all of those, and all these things are checks that have been put in place to protect every one of us. So it's always important that we cultivate these things as habits, so that in the end, you don't find yourself in a court for something you just waved aside at the initial point, thinking that they are not important. Because for them to be there by the put there by the other party means that he's foreseeing that circumstances like this may arise. So it's always good for you to also put yourself in check and protect yourself, so that in the long run you don't suffer unnecessary losses.
I see Barrister Musa just clicking, yes, I agree, just so he can download whatever app it is, and all right, it's okay.
My own advice goes to employees in the course of carrying out your duties in your workplace. My own advice is they should carry out the duties carefully, diligently, honestly, sincerely, irrespective of the terms of agreement, if it's under pressure or duress that you've signed it, so that if later in future or eventually there is an issue, your good act or good deeds can speak for you, and your employer can take up such damages which they see that you cannot handle. So it's advisable that they should be very careful and diligent in dispensing their duties in their workplace.
Okay, thank you very much, Barrister Uche and Barrister Musa, for being here on Probono Chambers. We'll do this again tomorrow. And thanks to those who participated by calling in and by simply listening and smiling for when there was a reason to smile. My name is Ruth Usman. I'll be back in the 11 o'clock hour on Media Lab.
Welcome, my dear friends.
Human Rights Radio. Your 100% effort is not good enough. Give me 101.1 effort.
Welcome, my dear friends.
Human Rights Radio. Your 100% effort is not